Hello everyone, my name is Olga Cronin and I'm Policy Officer with the Irish Council for Civil Liberties and the International Network for Civil Liberties Organisations, otherwise known as INCLO. I'd like to welcome everyone here today to INCLO and Privacy International's side event to the UN Human Rights Council's 45th regular session currently taking place in Geneva. Our discussion today is about facial recognition technology and protest, and we're very happy to be holding this event with the UN Special Rapporteur on Peaceful Assembly and Association, Clément Voule. Before we get started, I'd like to mention a little housekeeping. People who've joined us today have the option of hearing this event in Russian, Spanish, and Arabic. If you wish to listen to our speakers in any of these languages, please choose the relevant language after you click on the interpretation at the bottom right of your screen. Please note that our Arabic translator is actually assigned to the German tag. So if you want to hear our speakers in Arabic, speak in Arabic, please click on the German option. I'd also like to point out that we will hold a question and answer session after all the speakers have spoken individually. So anyone who may have a question or questions for any of our speakers, please write your question or questions in the chat box on the right of your screen in English. So again, I'd like to welcome you all here today to our event called Spying on Dissent, Facial Recognition Technology and Protest Harms. By way of background, INCLO is a network of 15 independent national human rights organisations from around the world, and it includes the Irish Council for Civil Liberties, Liberty in the UK, and Agora in Russia. Privacy International is a London-based charity which investigates government surveillance, litigates to ensure it is consistent with the rule of law, and advocates for strong laws that protect privacy. So along with Mr. Voule, we're also delighted to have three great speakers with us today. They are Mr. Ioannis Kouvakas, Legal Officer at Privacy International, who will speak to us about the international legal landscape and challenges in respect of facial recognition technology at protests. Our second speaker will be Mr. Ed Bridges, a citizen activist based in Cardiff in Wales, who, along with the human rights organisation Liberty, took the South Wales Police to court over its use of live automated facial recognition technology. Mr. Bridges' action led to the groundbreaking ruling in the UK Court of Appeal just last month that the use of facial recognition technology by police is unlawful. Our third speaker will be Mr. Kirill Koroteev. He is head of international practice at the Agora International Human Rights Group in Russia, who will speak to us about a complaint that Agora has lodged to the European Court of Human Rights about the use of facial recognition technology in Russia in regards to protesters. And finally, lastly, but definitely not leastly, we will hear from Mr. Clément Voule, who will speak to us about the rights at stake when facial recognition technology is used by authorities at protests. Just before we get started, and for those who are perhaps unsure of how facial recognition technology works, I would like to explain very briefly and in a very broad sense how it works. There are in fact several ways in which FRT works, but one main method involves assessing whether two facial images depict the same person, and this involves the use of a pre-existing database of images. So if a person is at some location where certain FRT cameras are used, this could be a shop, a street, or a protest, a digital image of that person's face is taken, and this image is processed to extract biometric data. And biometric data is essentially the measurements of a person's facial features. This newly captured image is then compared with biometric data from images of people already compiled or held in a database. So for example, in Mr. Bridges' case, which we will hear more about later, he was attending a protest where these kinds of FRT cameras were being used by police. So his image would have been captured by the cameras, and in turn the police would have compared his image with a compilation of images or watch list to see if there was any match. The South Wales Police watch list, the UK Court of Appeal heard, includes images of people who have previously been in custody, people who are wanted on warrants, people who are unlawfully at large, people suspected of having committed crimes, and people who may be of interest to the police. The idea being that if a police officer believed a match had been found, they could then go on to stop, search, and perhaps arrest that person. So one can see how this type of technology and this type of surveillance clearly engages people's right to privacy, their right to freedom of assembly, their right to freedom of expression, and their right to associate, to freely associate. Given the importance of the right to protest in democracies, we have to ask ourselves, how does this technology affect our right to protest? So without further ado, let's see what our speakers have to say. As I mentioned earlier, our first speaker is Ioannis Kouvakas, a legal officer at Privacy International, who will speak to us about the legal landscape and challenges in respect of FRT. Ioannis, please lead the way.
Hi, and thank you, Olga. Thank you very much. And allow me to also thank all those who helped to make this event happen today. Privacy International has been working at the intersection of human rights and new technologies for quite some time now. And we believe that facial recognition technology raises a series of important questions and challenges in this respect. Privacy has become all the more essential in the age of data exploitation. The way data and technology are now deployed means that our privacy is under an increased threat, and on a scale that we could not have imagined 20 years ago. At PI, we believe that facial recognition technology presents grave questions, not just for privacy and data protection, but also for the exercise of all human rights that support the functions of today's modern democracies. We believe that the use of facial recognition technology during protests does not adhere to human rights, as it fails to abide by fundamental principles enshrined in international legal instruments, as we will see later on. This was also recognized by the UN High Commissioner for Human Rights in her recent report, which touched on the impact of new technologies on the right to protest. In this short presentation, I will give a quick overview of how the current legal framework interacts with this surveillance technique, and also refer to some of the challenges it poses for modern democracies, focusing mainly on how this technology interacts with two fundamental principles that interferences, including also with the right to privacy, need to abide by, namely necessity and proportionality. Both the Universal Declaration of Human Rights and the International Covenant on Civil and Political Rights guarantee our right to privacy, as well as our right to peaceful assembly. When it comes to the latter, the Covenant requires that any restrictions that are imposed on the right to peaceful assembly need to conform with the law and be necessary in a democratic society. The Special Rapporteur on the rights to freedom of peaceful assembly and of association has called for the prohibition of indiscriminate and untargeted surveillance of those exercising their right of peaceful assembly in both physical and digital spaces. He has underscored that surveillance of protesters should only be conducted on a targeted basis, and when there is reasonable suspicion that they are engaging in or planning to engage in a serious criminal offense. This again should be based on necessity and proportionality, two fundamental principles that underpin how interferences, including with the right to privacy, need to be regulated. And these principles have been further enshrined not only in national constitutions and laws, but also in other supranational legal orders. For example, we come across necessity and proportionality in the European Charter of Fundamental Rights or in the European Convention on Human Rights by the Council of Europe. With regard to legality, I would just like to highlight the following. In our work on challenging government exploitation and government surveillance, we have seen a growing tendency by governments to circumvent transparency and accountability principles. Sometimes, governments even work with private actors in secret. They entrust them very intrusive surveillance capabilities or functions, which might also include the use of extremely intrusive surveillance technology, such as facial recognition. In our view, These instances make the need for complete transparency, accessibility, and clarity of the law, as well as an intense debate for any rules governing the use of this technology, even more compelling. Moving on, I would like now to focus on the necessity and proportionality principles and standards that I mentioned, which we believe are the very essence of what constitutes the necessary in a democratic society requirement. This is a requirement that the aforementioned laws impose, the international framework generally imposes, as I mentioned. Necessity and proportionality mean that any interferences with fundamental rights need to be limited to what is strictly necessary and proportionate to the aim sought. This consequently requires the police, for example, to first prove a concrete, specific, and immediate threat to, let's say, national security or public safety that would justify deploying this very kind of technology. This is the necessity aspect of this requirement. Secondly, national authorities, police, for example, again, must demonstrate that the use of a technology like facial recognition would override any fundamental rights implications that would legitimize its use. It requires, for example, a balancing exercise, what we call proportionality, between the benefits and the impact of the technology on people's fundamental rights. At this point, it is important to note that police forces around the world have attempted and generally failed to specifically justify the need for facial recognition deployment. Uses of such technology have been met with a considerable degree of errors and inaccuracy. And I'll just refer to a few examples. There is a test conducted by the United States-based Civil Liberties Organization, the American Civil Liberties Union, ACLU, in July 2018, where facial recognition software incorrectly matched 28 members of Congress, identifying them as other people who have been arrested of a crime. In the United Kingdom, research has shown that facial recognition has proven to be extremely inaccurate. Specifically, Metropolitan Police's and South Wales Police's matches have wrongly identified people up to 98% of the time, which equals to more than 2,500 wrong matches in total. Even more so, in the context of protests, it is hard to see how deploying facial recognition can never be limited to what is strictly necessary. As a form of mass surveillance, facial recognition will most likely fail to adhere to any necessity standards. And when it comes to proportionality, the very balancing exercise between the benefits of facial recognition and the human rights harms it brings, it will be most likely incapable to adequately incorporate the extent of the negative implications that facial recognition has, or, for example, the chilling effects that accompany facial recognition. For instance, authorities would likely not be in a position to precisely assess the exact number of people who have chosen not to attend a protest or a public event, for example, sacrificing their freedom of expression and assembly rights over legitimate concerns relating to abuse of their biometric data by the police. These people, for example, might essentially choose to stay at home and proactively not exercise their freedoms out of fear that they will be targeted by surveillance. The Special Rapporteur on the Promotion and Protection of the Right to Freedom of Opinion and Expression has underlined this very chilling effect, which can long-term shape and restrict the capacity of targeted communities to fully and freely exercise their rights. This is because these communities will most likely, and the people targeted, will most likely know and avoid going out in public spaces, exercising their fundamental rights, when they run a high risk of being unlawfully and disproportionately affected by intrusive technologies such as facial recognition. This all contributes to the balancing exercise being inadequately carried out or wrongly carried out by national authorities, leading to indiscriminate and disproportionate effects that fail to keep facial recognition techniques in line with human rights laws. To conclude, I briefly refer to the international legal framework focusing on legality, necessity, and proportionality, three principles that commonly underpin international and regional texts. With a focus on necessity and proportionality, we saw how challenging it will be for authorities to properly adhere to these requirements. Facial recognition is a technology of an unprecedentedly intrusive nature. It can have both immediate and long-term chilling effects on affected communities. These onerous consequences are not just limited to privacy, but also impact other rights that too constitute the very essence of our democracy. These are rights like our right to peacefully protest and assemble. Privacy International believes that facial recognition technology should never be deployed during protests, as it fails to adhere to international human rights law and standards. Thank you very much.
Apologies, I didn't realize I was on mute. Thank you, Ioannis, for your detailed and very thorough overview. It serves as actually as an excellent primer for our next speaker, Ed Bridges, who, as a concerned citizen, as I said earlier, took the South Wales Police to court over their use of FRT and ended up succeeding in the UK Court of Appeal last month. The floor is yours, Ed.
Thank you, Olga. Well, Prynawn da o Gaerdydd yn De Cymru. Good afternoon from Cardiff in South Wales in the UK. And thank you for the opportunity to speak today. I'm somewhat intimidated by the knowledge and the expertise of today's contributors and audience. I come to this subject not as a data scientist or as a lawyer, but purely as a concerned and interested citizen. I'll say a little bit about my case and the concerns I have about some of these issues more generally, but I'm also particularly interested to listen to what others have to say. I had no particular desire to involve myself actively in issues around data privacy and civil liberties. I live a rather boring life. I'm a dad of two. I have an office job at my local university. I'm a football fan. And at no point did I wake up one morning and think I really want to take my local police force to court for a bit of fun. But fundamentally, I think that the greatest gift a government can bestow on its people is the right to be left alone. So as a law-abiding citizen quietly going about their business, I was discomforted and a little concerned when I saw a facial recognition van parked on my local high street back in December 2017. There was no warning it was going to be there. No one was giving out information to passers-by or explaining why it was there. And people had no way to opt out from having their data captured, because by the time they were close enough to see what was happening, they would already have had their image taken multiple times. But for me, and particularly relevant to today's discussion, the line was crossed by South Wales Police a few months later when facial recognition technology was deployed against a group of peaceful protesters campaigning against an arms fair being held in Cardiff. I was there that day, stood making polite conversation and sharing biscuits with assorted Quakers and peace activists. And across the street, our local police force were filming us and comparing the footage against a watch list using facial recognition technology. Now, as I said at the start, I'm a football fan in the UK, and in the course of watching my share of football matches over the last 25 years, I'm fairly used to the police pointing a camera at a crowd that I might be part of. And whilst I don't much like that experience, it is part of the surveillance culture that we have in the UK. But deploying facial recognition against a crowd of peaceful protesters strikes me as being significantly different for two key reasons. Firstly, unlike when a camera or a video camera is pointed at a crowd, facial recognition technology doesn't offer the same rights and protections to citizens who are affected by it. If the police carry out surveillance on a crowd of which I'm a part, I can write to the police force and request to see photos or footage under UK data protection legislation. It's a cumbersome process, but having tried it a few times, it does broadly work, and it can reassure the public what information the police are holding on them and why. But because of the way facial recognition technology works, the same safeguards can't apply. It's not a single image being captured, but a unique biometric map of your face, as Ioannis said. It's more akin to a digital fingerprint. And this is a point on which the UK courts agreed during my case. This is the processing of unique biometric data, even if it only takes a few seconds to happen. So to me as a citizen, I would like to see safeguards put in place so that if the police process my biometric data without my consent, that I can be aware of that fact and I can have the same recourse as if I felt it was being done unnecessarily. And the second point I'd make, and perhaps a more fundamental one, is that deploying facial recognition technology at protests is a matter that should concern us all. I hold a rather old-fashioned view that the police should assist peaceful protests and not undermine it. In fact, the Welsh word for police officer is heddwas, which literally translates as servant of the peace. But if you point a camera, which has the capacity to take people's uniquely identifiable biometric data at them, even if you don't retain that information for long, and this comes back to the point Ioannis made, you will inevitably make people feel reluctant to use their right to peaceful protest. It's one thing handing over data to your local cafe so you can have a meal out with your partner under COVID restrictions. It's quite another to give your data to the state when you're protesting about something with which the state might disagree. One only has to look at the use of facial recognition technology in Hong Kong during recent protests to see what that contradiction can lead to. And whilst I'm not for a moment drawing a parallel to the use of technology in the UK, we live in febrile political times, and as citizens we should always be on our guard. Our right to privacy is hard won and it shouldn't be lightly relinquished. I repeat what I said at the start. The greatest gift a government can bestow on its people is the right to be left alone. And so, as a result of those concerns, I brought a legal challenge along with the UK human rights group Liberty to challenge the use of facial recognition technology by South Wales Police. And the use of that technology against peaceful protesters was an important part of that case for the reasons I've outlined already. A lot has been written about the case, and no doubt this audience will have their own insights into the judgment. But as dispassionately as I can, I would say that there are some major ramifications to the judgment that we had last month, where the Court of Appeal upheld our judicial review and found against South Wales Police. In essence, the court found that the legal framework governing the use of facial recognition technology in the UK was insufficient, and the use of technology was unlawful in relation to three specific elements of South Wales Police policy. Firstly, that their privacy impact assessment was written in a way that facial recognition technology could be used to find absolutely anyone of interest to the police, which in the court's judgment left too broad a discretion vested in individual police officers. There have been instances in the UK, for example, of UK police forces putting people with no criminal record onto facial recognition watch lists simply because they've come to the police's attention because of mental health issues. And I would argue that that is a good example of police overreach. The second point was that when it came to the police's public sector equality duty, the court judged that South Wales Police had never sought to satisfy themselves that the software programme, in this case, did not have an unacceptable bias on grounds of race or sex. And at a time when Black Lives Matter has highlighted the huge disparities which exist between different racial communities' treatment by the police, that's clearly a matter that should concern us all. And finally, the court found that South Wales Police's data protection impact assessment failed to assess the risks to the rights and freedoms of members of the public who are scanned. At the time South Wales Police started using this technology, many of us felt that their attitude towards civil liberties concerns was gung-ho and complacent, and the judgment vindicates those concerns. And by winning the case, I think we've ensured there will be a tightening of what might otherwise have been a rather slack approach to the law. But there is still an awful lot to do. Somewhat bafflingly, the Metropolitan Police in London have said they will continue to use facial recognition technology more or less as they were beforehand, rather arrogantly, I think, arguing that policing in the UK capital is completely different from out in the provinces, and that all of their policies are marvellous and don't need to change. I paraphrase somewhat. And I expect South Wales Police will continue to use the technology after they have updated those elements of their policies that I mentioned earlier. What will happen next remains to be seen. I know Liberty will be watching the situation closely. But in closing, my message really is that individuals can and should seek to redress overreach by the state into our private lives. And facial recognition technology is a clear exponent of that. Our right to peaceful assembly and peaceful protest is fundamental in a democracy, and we should be able to do so without fear. And at times we may wish to exercise that right anonymously, perhaps precisely because we are protesting about something with which the state or our employer or our partner disagree. That right is simply incompatible with facial recognition technology. And as such, if the technology is to be used at all, then very clear safeguards have to be put in place to ensure it protects rather than undermines our human rights. Diolch yn fawr iawn. Thank you very much.
Thanks a million. That was brilliant, and I loved the Welsh. And congratulations on your win. Your presentation serves as a timely reminder of how action taken by a concerned citizen can have a significant impact on the laws and policies governing us. And I'm sure many human rights lawyers around the world will be dissecting that judgment for some time to come. Speaking of human rights lawyers, I'd like now to welcome Kirill Koroteev, who is the head of international practice at the Human Rights Organization in Russia. As previously mentioned, earlier this year, Agora lodged a complaint to the European Court of Human Rights about the use of FRT at a protest in Moscow, a protest that was actually held in support of protesters. So welcome, Kirill.
Good afternoon or good morning, depending on where you are, and thank you for the invitation. It's an immense honor to speak after Mr. Bridges, because we here in Moscow were following his case with much attention already when it was dismissed by the High Court. And we had to file, because of the deadlines, we had to file our application to Strasbourg before the Court of Appeal judgment. But even, the High Court, which was against at Bridges, was, we think, still in our favor. So that's how bad the situation in Russia, at least we say, is. So basically, it won't take much time to explain, I hope. The situation was that last year there were protests in Moscow over the city elections, and a lot of people were detained, criminally charged, and tried, and ultimately convicted. So there were also gatherings in their support, and one of those was on the 29th of September, a relatively big event with around 30,000 people present. And it is a regular practice of Russian authorities, which is contrary to Article 11 of the European Convention on Human Rights. But what they do is they install fencing around the area for the demonstration and leave only the designated entry points where people can be searched. And on the 29th of September last year, what happened is that there were cameras installed at an average person eye height. Just like you couldn't avoid it. So the only place you could enter is here, and there is a camera facing you. So it was that's how. And because we believe it was taken on the grounds of legislation that was not providing individuals with an effective remedy, we had to apply to the European Court within 6 months of the event. Well, extended to 9 months, sorry, because of the lockdown caused by coronavirus. Really, there is now
Hi, I think we're having a little bit of trouble with Kirill's link. So sorry to cut across. I hope Kirill is okay there. But we might move on to Clément and we might come back to Kirill if that's okay.
Yes.
Thanks, Clément.
Can I or we still
Yeah.
Okay, great.
Yeah, thank you. Sorry, I should introduce, this is the UN Special Rapporteur for Peaceful Association and Assembly. Thank you very much for being here today.
Yes, thank you, Olga. Good morning, member of the panel and those of you who are joining this webinar today from all around the world. It is a great pleasure for me to connect with you. Let me thank INCLO for hosting this important webinar and keeping the Human Rights Council engaged in this critical issue. The right to freedom of peaceful assembly is among the most important human rights we have. Together with the right to freedom of association, the right to peaceful assembly protects people's ability to come together and work for the common good. As recognized by the recent adopted General Commentary 7, the right to freedom of peaceful assembly enables individuals to express themselves collectively and to participate in shaping their societies. The repression of the right of peaceful assembly is a marker of authoritarianism and the erosion of democracy. In my 2019 thematic report, I affirmed that the use of surveillance technique for the indiscriminate and untargeted surveillance of those exercising their rights to peaceful assembly and association in both physical and digital space should be prohibited. Surveillance against individuals exercising their rights of peaceful assembly and association can only be conducted on a targeted basis where there is a reasonable suspicion that they are engaging in or planning to engage in serious criminal offense, and under the very strictest rule operating on principle of necessity and proportionality and providing by close judicial supervision. I believe the deployment of mass surveillance technology in the context of peaceful protests is inherently disproportionate, violates the individual right to privacy in public space, and exert significant chilling effects on decision to participate in public gathering. This includes mass surveillance or bulk collection and analysis of all communication metadata and the deployment of international mobile subscriber identity capture device. Digital technology that can be used to identify and survey and amass and in an automated fashion all individuals who participate in a particular gathering or are present in public space cannot be considered proportionate. Face recognition technology deployed at large public gathering and peaceful demonstration raises the same proportionality concern. The use of this technology typically requires the mass and indiscriminate collection and processing of facial image of all persons captured by the system. It can hardly be done in a targeted manner that will be needed to meet the need, the necessity, and the proportionality tests. My mandate had received concerning information about the increasing use by security forces around the world of facial recognition technology at peaceful protests, including as allow real-time identification and tracking of participants. Governments argue that these technologies are needed to counter terrorism or other national security threats. We must sacrifice some level of freedom to protect people from these serious threats. But the multiple negative effects of the use of this technology on the rights of peaceful assembly outweighs claimed benefits. Facial recognition technology creates a chilling effect and discourages people from participating in public gathering and demonstration in public places. Large gatherings allow individuals to express their view in the collective with an implicit anonymity. People feel safe to express their view because they are joining others. If they know that they can be identified and suffer negatively consequences, the likelihood of people joining demonstration will be significantly diminished in many countries around the world. It is highly intrusive. This system relies on the capture, extraction, storage, or sharing of people's most personal data or biometric facial data in absence of consent. It can create false positive, wrongly flagging people for criminal prosecution and detention. It perpetuates and exacerbates discrimination, including against Afro-descendants and other minority, women, or persons with disability, not only because it can be used to profile individuals or on the basis of their ethnicity, race, national origin, gender, and other characteristics, but it can bias against the member of this group and communities. I echo the finding of my colleague, UN Special Rapporteur Tendai, that technology is never neutral. It reflects the value and interests of those who influence its design and use. And it's fundamentally shaped by the same structure of inequality that operates in society. She cited how a 2019 review of 189 facial recognition algorithms from 99 developers around the world find that many of these algorithms were 10 to 100 times more likely to inaccurately identify a photograph of Black or East Asian face compared with a white one. In searching a data to find a given face, most of them pick incorrect image among Black women at significantly higher rates than they did among others, demographic. The capacity of this technology to further shrinking the democratic space of people living in the margin of society cannot be ignored. For this reason, I'm happy to see that the report issued by the High Commissioner concluded that overall, the use of this technology during peaceful assembly should be discouraged and call states to never use facial recognition technology to identify those peaceful participating in assembly. I support this call. The problem does not only lay on government. There is a global surveillance industry that is providing governments across the world with relatively low-cost access to the facial recognition technology. In my report, I call on digital technology companies to meet their responsibility to respect intersectionality, international accepted human rights standards, including the right to freedom of peaceful assembly and association. To that end, the effective implementation of the guiding principle on business and human rights should be a priority for these companies. Digital technology companies should make policy commitment to respect peaceful assembly and association, to conduct due diligence in relation to these fundamental freedoms, including through regular rights impact assessments and establish effective remediation process to provide compensation and other forms of redress when violations occur. These obligations involve all digital companies, including those in the surveillance industry. States should adopt and enforce law and policy that focus on creating mandatory requirements for digital technology companies to exercise due diligence to identify prevent, mitigate, and account for how they address human rights impacts of their business and products, and well as far robust transparency and remediation mechanism. They should be adopted only after a full, inclusive, and participatory consultation process with the relevant stakeholder. Moreover, I echo the call by the former Special Rapporteur David Kay for states to impose a moratorium on granting export license for surveillance technology until the use of those technology can be technically and legally restricted to lawful purposes that are consistent with the international standard. In conclusion, the guiding principle should be that the use of surveillance technique for indiscriminate and untargeted surveillance of those exercising the right to peaceful assembly and association, both in physical space and online, should be prohibited. The City of San Francisco decision to ban local governments' use of facial recognition software is a good example in this regard. States must take swift and effective action to ensure that facial recognition technology is only used when meeting the legality, necessity, and proportionality text, and never to identify the participant of a peaceful protest and after a meaningful public debate, nothing less. This system must be subject to robust oversight mechanism and transparency law. I thank you for your attention.
Thank you very much, Clément. That was an excellent a piece put forward by you as to the problems with FRT and what states are doing. I did find it very concerning when you said that you've seen an increase, that your mandate has seen an increase in security forces. We might come back to that. I was just going to get maybe Kirill, if he's back, he could probably maybe finish what he was, finish your presentation. But in the meantime, if anyone else who's watching would like to send us questions, please feel free to put them in the chat box. Okay, thanks, Kirill.
Thank you. I'm sorry, my connection stopped working when I started speaking, but essentially what I wanted to say is that the cases that are now being decided by Russian courts are nowhere near the case of Ed Bridges, and essentially what we hear from the courts in Moscow is that, well, even your personal data are not an issue because, well, it is your face, and because it is not attached to your name, it is not personal data. So that's how the courts stretch the law to say to just avoid striking the regulations down. The regulations are, by the way, very vague. Just saying that Moscow City Hall may keep on it what it recorded on its cameras, which are everywhere. So saying that personal data is not engaged, the courts also find that, well, it's not the courts, it's one of, we couldn't get disclosure of much of the algorithm and public procurement from the Moscow City Hall. However, what we got was one page of the internal communications between ministries, and the event of 29 September was particularly targeted. It was the only event last year at which Moscow City Hall and the Ministry of Interior used facial recognition cameras, and it was an opposition event. So in Russia, it's probably not so much the problems of gender or race, but your political convictions. So if you are attending an opposition event, well, you are likely to be facially recognized. And of course, the thing is that the government keeps your digital photo when you apply for a passport or for some other documents. So there is no problem, especially for the Ministry of Interior, to connect your image when you are attending a position meeting to your ID, which they took probably several years ago when you were applying for your passport or for your driving license. So it presents a challenge of principle for us. And well, in Russia, the allegations of discrimination are linked to political participation this time, and when we have the nearest occasion to update the European Court of Human Rights, we will, of course, extensively summarize the Court of Appeal in breaches. So the European Court of Human Rights listens very attentively to what English judges say when, it tries to appease the British government to avoid its criticism. I hope this time, when British judges decided in individuals' favor, European Court of Human Rights will also be attentive, because, well, Russian judges are not.
That's excellent, Kirill. Thank you, and thank you for coming back. So
I'm happy to.
So now we have a couple of questions. So there's a question for Ioannis. Are you aware of any policies or legislation globally that properly regulates the use of FRT? How do we push for appropriate policies and laws, or should FRT simply be prohibited in all its guises?
Thank you, Olga. As I mentioned in the beginning of my presentation, the issue with facial recognition technology is the fact that most of the times, if not always, it will fail to adhere to fundamental human rights law principles, as these have been enshrined in various national texts or international texts. And the issue is, while it is on its own an unprecedentedly intrusive technology, and a technology of a very or extremely intrusive nature, because it very specifically deals with our biometric data, which cannot be altered, cannot be changed, and at the same time it poses grave security concerns, both for the controllers of this data or the institutions that facilitate the exercise of facial recognition systems. It's still very hard to see if there can be a proper framework to regulate their use. We are not aware of a very specific framework that seeks to properly, or at least regulate the use of facial recognition technology in a human rights compliant way. However, I'll just briefly refer to those temporary bans or moratoriums, as they have been called. And I want to draw the attention of the participants to statements made by various technology companies or companies providing this technology to various police forces and government departments and institutions. We saw, for example, last summer that Amazon was suspending the provision of facial recognition technology to the police in light of the Black Lives Matter movement and protests that were surrounding the US and other parts of the world. And while these bans seem to be quite promising, we should not forget that they're just temporary and they don't always cover all the uses of facial recognition technology. And unfortunately, I do not think we can leave this matter to the discretion or motivation of individual companies that have their own aspiration of working together with governments and rising up as a hybrid institution of exercising intrusive policing functions. It is therefore questionable, considering again the nature of this technology and how intrusive it is, whether there can be a democratic framework where we can properly deploy facial recognition technology, and whether there can ever be instances where facial recognition technology can adhere to strict necessity and proportionality compared to other surveillance techniques and compared to other means that are in the disposal of state authorities. We do not see the reason for this extremely intrusive technology to be deployed when it comes to the exercise of various other fundamental rights. As I said, it's not just an issue of privacy or data protection. We can see that there are indirect effects and chilling effects also on freedom of association, freedom of speech, and freedom of expression. And if we balance the benefits and the harms, it's very hard to see if eventually any use, no matter how strictly regulated it is in law or transparent it might be, it will still be it will ever outweigh the harms.
Brilliant, Ioannis. Thank you. Thanks very much. We have another question there for Clément. Technological bias is receiving more and more attention. What would you like to see from civil society in responding to this bias? Is there scope for more public interest technologists? Is Clément there?
Yes, sorry, it's always quite difficult between me trying to open my macro. Sorry, thank you very much for this question. I think civil society is doing quite a lot in terms of preventing this the acquisition of this technology, but also its use by many countries. I think it's still important, like this event that you are organizing today, to continue to raise an important issue that this technology causes, not just only on the work of civil society, but also in general, and how this is marginalized and increase the inequality that we are seeing in society. And I think it's important also to continue to emphasize that this technology then really been, for example, opportunity, like some government mentioned, to fight against organized crime, counterterrorism. It's end by more restricting the democratic space. And it's if we don't do anything to ensure that the use of this technology is narrowly controlled and narrowly regulated, we will end by really undermining or kind of killing this ability of people to enjoy the fundamental right, which is also freedom of peaceful assembly, but also the privacy issue, also enjoyment of other rights, because some of these rights are in the core of the enjoyment of other rights.
Thank you, Clément. I have just a question there for Ed. Ed, was there any, someone has asked, was there any personal costs to you in taking on the Welsh police? Do you have any suggestions for activists who seek to use strategic litigation?
I suppose the obvious one is to work as closely as you can with existing civil liberties groups who understand the complexity of the law and understand how to take it on. But I come back to what I said in my presentation, really, that, you know, individual citizens should feel empowered to challenge this. This is a fundamental issue of principle, you know, particularly in relation to the right to protest, because if we want to protest about something, it is more than likely protesting against something, protesting on a matter where we are at odds with our government. And the need to be able to do that without having our data taken by the state is a fundamental issue of importance. So whilst taking on your local police force is not necessarily a pleasant or enjoyable use of time, it is something that is a really valuable and worthwhile thing to do. And yeah, anyone who is thinking of doing so, I would encourage them to liaise with the civil liberties organisations in their country who can help them to do so.
That's great, Ed. Thank you. We also have another question from Federico Efron. Can Clément develop the idea of technology is not neutral?
Yes, great. Am I on? Yeah, with my camera, sorry. Yes, yes, I emphasize that the technology is not neutral, and this comes from my colleague, the Special Rapporteur on Xenophobia, Tende, who also mentioned that the development of the technology is always triggered by those who develop it and those who want to use it because they have a specific purpose on developing that. This is why, for me, it's important that any technology that is developed should go through the issue and the principle of proportionality and necessity, but also go through the impact assessment on human rights. And we know that this technology, and I highlight some of the experience that she found in her report, that in many cases, this technology ends by confusing those coming from minority, like Afro-descendant, like a criminal, and that's the tests realized from companies to see if those technology really reflect the reality. We saw that those tests shows that in many cases, Black people or Asian faces will be highlighted as a criminal faces, or will be the one that will pump up first. So this technology, because they are developed in a way that the sense of those who develop it doesn't have this broad mind in terms of indiscriminate approach, in terms of how to avoid that those technology can be served for the purpose of all society. It ends sometimes by reflecting the fear of those who develop this technology because they have something in mind. In most of the cases, let us be honest, police will always take Black people walking on the street like a criminal. So the technology also that will be developed by developer will also feature him as the man. The algorithm, we know how those kind of things were developed. If you saw this kind of skin or you saw this, they are primary people that you need to target. This is what we are seeing. And this is where we are saying that it doesn't really, until now, there is nothing that shows really that facial recognition technology help really to fight against terrorism. It may help in few cases to identify some criminal, but the harm that it causes for the society is beyond what we can expect as advantage. This is why we are calling really to kind of stop, in particular when it comes to the peaceful protest, because if it's not targeted, then it's completely confusing.
Thank you, Clément. I actually have one more question for you, sorry. Someone has asked, what international regulatory bodies do you think requires more advocacy engagement in this regard?
Well, I think I mentioned that I think if we go to the international norms, we have already the guiding principle that is there that require for the companies to be able, every time they develop their product, to be able also to ensure that they respect the international standard and to implement the due diligence. And what this means? This means that in developing their product, in implementing their product, they need also to ensure that this does not have a negative impact on human rights. Well, we have this within the Human Rights Council, but I think today that we need also to alleviate this advocacy even at the Security Council level, because how do we ensure that it's implemented? We have recently, since 4 years now, we are also embarked in the development of these binding instruments, but we don't know when these binding instruments will come. Will be born. But what we need to still doing is also to find the avenue, including Human Rights Council level, including the General Assembly level, to ensure also that the companies are called really to their task, but also the government also, because many companies also argue that some of these technology are not used to the purpose that some government buy them. So we need also at the national level to continue our advocacy, litigation, and I think Bridge also mentioned some of this, but we need to be in all fronts where we can, including also pressure on the company themselves.
Brilliant. Clément, thank you so much. And I think that's a great way to end our discussion today. I'd like to thank all our speakers and to everyone who joined us. I hope you enjoyed it. I'd also like to say a big thank you to our translators, Leila, Fabian, Mohammed and Farkad, and to Andrea and Mike for helping things to hopefully run smoothly. I think the speakers have given us a lot to think about, and I'm sure that the use of facial recognition technology at protests and other situations will be the subject of many, many conversations to come, whether you're sharing biscuits with your friends at a protest or you're at the UN. So, so many thanks, and thank you very much for joining us today.